Hello and welcome to the Rodgers Brief, where each week I bring you some stories from across the country and often particularly from Nova Scotia. I'm a Nova Scotia-based lawyer that deal with issues that are in the news that have either a legal angle to them that is underappreciated or else it's very prominent. So this week I'm going to bring you actually 7 different stories, and some of them are Nova Scotia focused, and I think 3 of them I'd consider to be more national stories. Actually, I'm recording this on Friday, and I just saw before I started recording that the Supreme Court of Canada came out with another decision as well, so I'll make that 8 stories. The decision today, Beaver and Lambert, was a case out of Calgary, and these 2 individuals had confessed to killing their landlord, except so the issue was whether the confession was admissible because they had they'd been arrested without being given their charter warning, their charter rights given to them. Then they were brought back to the station. Police realized they hadn't been given a charter warning. That was provided, and then they started over, and eventually the 2 confessed. So the issue was, well, is it possible for the police to make a fresh start and give you your charter rights after they've already been breached? And the Supreme Court said yes. Where each or one of them at least, had spoken to a lawyer. The confession was voluntary, and so it was considered admissible as a confession, and so the 2 are now convicted of manslaughter. Anyway, that's a story that's just come out fresh off the presses online, on Twitter, so I had a quick look at that before I started here. I may take a closer look at the full decision. That was just sort of reading the head note, so we'll see. Okay, the other stories I want to talk about today, there was a Nova Scotia Supreme Court decision on the Halifax Catholic Diocese settlement. There's a story of Sia Van Wyck. This is from 2017, although it's been covered more recently by the Nighttime podcast. There's a story this week about the Quebec Human Rights Commission dropping 200 cases, and I'll talk about the reasons for that. The Crown in Nova Scotia is seeking leave to appeal to the Supreme Court of Canada after Leslie Greenwood was successful in his appeal to the Nova Scotia Court of Appeal on his conviction to the shooting deaths of Barry Mercereau and Nancy Christensen back in 2000. This has gone through the Court of Appeal twice now. Then I'll talk about the Ecology Action Centre and the New Brunswick Anti-Shale Gas Alliance versus the Nova Scotia Department of Environment case. This was to do with the Goldboro LNG project, not far from where I live here in Goldboro, and there was a highway realignment case. Anyway, it's a big LNG project, or it was at least a big LNG project proposal by Pier Day, and this was an issue where these environmental groups were seeking standing to oppose a certain element of it. So interesting decision out of the Court of Appeal here in Nova Scotia. Then something that's quite local to this area, and that is the Antigonish Town and County consolidation attempt that councils for the town and the county have voted to consolidate. There was opposition, and now a citizens group is suing the county for making that motion. And finally, I'm going to talk about Bill C-21, the federal legislation that's been introduced on firearms restrictions, and it's gotten lots of news and coverage over the past week or so. So let's jump into it. Actually, just a quick update before I get into that. Just from last week, I talked about the Alberta and Saskatchewan governments, provincial governments, their legislation that they brought in, the Alberta Sovereignty Act and the Saskatchewan First Act, both making attempts to, delineate provincial and federal jurisdiction and push back on any federal government attempts at, in their minds at least, interference, intrusion into provincial jurisdiction. Well, the Alberta legislation, which was quite controversial in one aspect in particular, which was if the legislature decided that there was federal intrusion, then cabinet was going to be empowered to then write new laws that fought back against that intrusion. Well, this is unusual because normally if you're going to enact a new legislation, you have to go into the legislature to do that. The existing legislation didn't require that. Now they've taken that part out, so making it a little more palpable. But despite that, they're still facing some controversy, including from First Nations opposition which was really short-sighted of both provincial governments not to bring First Nations leaders into the fold, because they're talking about federal versus provincial jurisdiction. Well, First Nations Aboriginal land claims, other rights are impacted by those discussions, and so certainly that should have been considered before legislation was introduced. Okay, so that's it for updates from previous stories. I'm going to talk about this week. I'll start off with just a quick comment on the Nova Scotia Supreme Court. It's a decision, but what the decision was, this was in the Halifax Yarmouth Catholic Diocese settlement. There was a class action settled against the Catholic priests in that diocese. This was very similar to the Antigonish diocese claimant situation, class action, with which I was involved close to 15 years ago now. And in that case, there was a settlement as well. This one is $10 million total. I think the Antigonish one was a $12 million settlement. So what happens now, there's an unknown number of claimants. There's 40 actually in the Halifax diocese that had already settled privately since 2007. But now others can come forward or have already come forward, and now their claims will be assessed within this $10 million total to see how much each person is entitled to receive. The maximum is $350,000 per person and a minimum of $30,000. And so anyway, it's a very uncomfortable thing to do, but you need to, in the Antigonish situation, there was an actual chart based on different violations, different sexual assault acts, and a person who suffered a certain one or a certain combination would be entitled to a certain number. And anyway, it's just the way you have to do things. The lawyers in this case, led by John McKeegan, a friend of mine, a really good lawyer who's taken on these class action cases, which take years to settle. There's a large contingency fee settlement as well. He's splitting with a firm in Ontario and others that were involved. So 33% contingency fee was approved by the court. That's not always the case sometimes, although 33% isn't an unusual contingency fee amount in a personal injury settlement case. With these class actions, sometimes the courts will bring it down just because the overall number seems too large. But these things take years to do, and there's lots of people involved and expenses, so probably not unreasonable for the amount of effort that went into it. Okay, that's just wanted to comment on that. So all the court had to do was really, the claimants in the diocese had reached a settlement. The court, all they had to do was approve it. They have done so. And they've approved the contingency fee. Second one is this terrible case of Sia Van Wyck. Miss Van Wyck was a 7-year-old who was killed by a farm tractor, guy, Roland Potter, down near Digby in Clementsville back in 2017. Was operating his farm equipment, was mowing some hay, and unfortunately Miss Sia Van Wyck was caught in the equipment and succumbed to her injuries at the IWK later that day. This has come in on my radar because people would know I appear, not irregularly, sometimes on the nighttime podcast Sunday evenings to talk about the Mass Casualty Commission proceedings. Well, the nighttime podcast is also covering this case of Sia Van Wyck because there was never any charges laid against Roland Potter, the operator of the tractor, even though there was pretty compelling evidence that he may have been consuming alcohol at the time, probably was, left the scene immediately, drove home with the tractor, which was a piece of evidence, drove the short distance to his house, started throwing back whiskey, which is just a common move for people that are get in accidents when they've been drinking. They go home, drink some more, try to, muddy the waters as to how much they'd been consuming. Well, it didn't matter in this case in a sense because the police never even put him on the breathalyzer. There was a private investigator's report from Tom Martin, a retired RCMP officer, well-respected private investigator, that showed that the police made quite a few mistakes in their investigation, and in fact there was compelling evidence of criminality on the part of Mr. Potter. But he's never been charged. There's consideration of a private prosecution. Anyway, there's so the Nighttime podcast has been covering this. There was a really good article by Lindsay Jones in the Globe and Mail about the lack of criminal charges against Mr. Potter. Now, Mr. Potter had been charged in a separate incident now with criminal harassment vis-a-vis another neighbor of the Potters. That's Brandy Andrews. And there's a Justice John Keith decision from 2020 where Mr. Potter was acquitted, represented himself in that case. So anyway, it's something I'll be following and maybe talking over this case some with Jordan Bonaparte on the Nighttime podcast sometime in the near future. Tragic situation. Heard the podcast with with her father. Anyway, very difficult stuff, but kind of compelling in its own way too. Okay, so that's Sia Van Wyck. We'll talk about the next one is the Quebec Human Rights Commission has dropped 200 cases. And the reason they've done so is that this is in reaction to the Supreme Court of Canada case acquitting or agreeing to the appeal of comedian Mike Ward. Now, Mike Ward was found responsible, found to have been in violation of the Human Rights Code in Quebec for mocking a young guy named Jeremy Gabriel, who's a singer, who's performed for the Pope. He's done national anthems, prominent Quebec singer with a disability. He had hearing issues as a child, misshapen head, and so Mike Ward had made fun of him during his act, and he's dark humor, adult comedian. So there was a claim made under the Human Rights Commission that Mike Ward had discriminated against Jeremy Gabriel on the basis of his disability. Supreme Court of Canada found, so it wasn't a claim in defamation, it wasn't, anything like that, it was that he had discriminated against him. Well, the Supreme Court of Canada said that's not a discrimination case. He wasn't made fun of because of his disability. He was made fun of because he's famous, and he's a public person, and he's susceptible to comedians making jokes about him. So the Supreme Court of Canada found that this was a freedom of expression issue, and that there was no justification for the human rights violation. Well, that all seemed clear to me, and I thought it should have been clear from the beginning that it was, this is a stand-up comedy act, and it should be taken in that context. But apparently there were 200 cases in Quebec, active cases, where such claims had been made, or similar enough claims that they've now been dropped as a result of this Supreme Court of Canada decision. So just kind of shows, I guess, sometimes what kind of overreach these human rights commissions can sometimes have. Okay, next story. This is a Nova Scotia case, but it involves an appeal to the Supreme Court of Canada, or potential appeal, and that's the case of Leslie Greenwood. Mr. Greenwood was charged with the shooting deaths of Barry Mercereau and Nancy Christensen back in 2000. Now there was another individual that was charged and was convicted of murdering them. Mr. Greenwood, it turned out, was there's a long story behind it. He had a drug debt and he was trying to pay it off. He was supposed to go rob a Brinks truck at a superstore. Instead, he was told, no, go kill these two people and your drug debt will be forgiven. Well, there was Mr. Greenwood and another individual that went. Mr. Greenwood stayed in the vehicle. The other person went in, shot the two individuals dead, and then and a third individual as well, unrelated. So the original convictions were overturned at the Court of Appeal in Nova Scotia in 2014. New trial was held in 2018 under Justice Jamie Campbell. The only real evidence, there was no evidence that that Greenwood was in the home. The only evidence was that he drove the other person there. He thought to pick up drugs and to complete a drug deal. And so what the evidence wasn't quite so clear that he knew anything about what the plan was, there was problems with the judge's instructions to the jury on that point. So the jury, the Court of Appeal found, could have misunderstood that it was possible to convict Mr. Greenwood even if he was just outside in the truck, perhaps not even quite knowing what was going on inside, but just being there, that he should have been aware or may have been aware of what was going on inside. So the Court of Appeal said that was the improper instruction to the jury, and so that he was perhaps convicted unfairly. So that this was the second time, like I said, he was brought to the Court of Appeal and was successful at the Court of Appeal. There was a new trial in 2018, convicted again. The Court of Appeal said no. And so now the Crown in Nova Scotia is trying to appeal that decision to the Supreme Court of Canada. I read the Court of Appeal decision, don't see that the Supreme Court of Canada would certainly overturn the appeal and re-enter a conviction. In fact, I don't think it's appropriate for the Crown to be even appealing this to the Supreme Court. I don't think the Supreme Court will hear the case. It wasn't a split decision at the Court of Appeal, so there's no automatic right to go to the Supreme Court of Canada. So be following that as well to see what the Supreme Court does. Mr. Greenwood, of course, now needs to respond to the application, and so we'll be following that case as it makes its way up to the Supreme Court of Canada. All right. Next case. That was Mr. Greenwood's appeal. Next case was actually also in the Court of Appeal in Nova Scotia, and I was following this because on Tuesday of last week, the Court of Appeal broadcast this case. Now, they don't often do this. They do more often than they used to, but every once in a while, the Court of Appeal will broadcast the arguments. And so I was watching the lawyers make their pitches. So the parties to this are the Ecology Action Centre, well-known environmental organization in Nova Scotia, and the New Brunswick Anti-Shale Gas Alliance, which is a less-known organization, at least to me, versus the Nova Scotia Department of Environment. And it's regarding the Goldboro LNG project. And this was a project that's been proposed now for, at least 10 years. There was an environmental review in 2014, so it's probably a little more than 10 years if they only had the environmental review case heard in 2014. But this case in particular wasn't to do with the entire project. The 2014 environmental review dealt with the project, the LNG terminal export project. This one deals with a highway realignment. So one of the things they need to do is move the highway to loop around where the project is going to be constructed. And nobody in the local area really cares about that. They're all happy to have the highway realigned if it means that's what the project requires. But the Ecology Action Centre and the New Brunswick Anti-Shale Gas Alliance have applied to the court to oppose that. So the issue isn't the substantive decision to make this road and do a detour around the new plant to be constructed. The issue in the Court of Appeal was whether those two groups could even have standing to make the application. All right, so the issue is, all right, they're not a party to it. They don't have land that's associated with it, but groups like the Ecology Action Centre can sometimes get what's called public interest standing. So to get public interest standing, there has to be a serious justiciable, that's an issue that can be decided by the courts, and a serious one. The plaintiff has to have a real stake or a genuine interest in the issue at stake, and that the proposed lawsuit is a good way to bring the issue to court. So in this case, it was actually the first issue where the plaintiffs had failed at the earlier stage. There was a decision already from Justice Darlene Jamieson that said these two parties didn't have public interest standing because the issue that they were trying to face, this movement of the road, wasn't serious enough. So those are the arguments they were making. Justice Jamieson said that it's not serious, it's just a road, it's not the entire project at issue, And it seems to be, and I know Justice Fichot from the Court of Appeal in his questioning seemed to suggest this just seems to be an attempt to go back and review the 2014 overall approval. And on top of it all, and Justice Jameson noted this, now we've gotten to the point where it's not even clear that the project is going to go ahead. Alfred Sorensen, the president of Pier Day, in July of 2021 said that the actual LNG terminal doesn't look like it's going to go ahead. So is it a serious issue? It's not quite so clear. The Court of Appeal justices sitting were Justice Wood, the Chief Justice of Nova Scotia, Justice Fichot, and Justice Van den Egen. There was, some... Justice Fichot made, I think, the point that the Court of Appeal, I think, will ultimately come back to, which is, if this was really about greenhouse gas emissions and the overall environmental impact of the project, then the proponents should wait for the impending greenhouse gas management plan from the province to come out, and then figure out how this LNG project or other major projects fits into that plan and oppose the plan if their goal is to deal with overall emissions. Actually, so the only final point I'll make on this, I was watching these submissions and I noticed the Ecology Action Center had two lawyers, a senior lawyer and then somebody who was a clerk or just a very junior lawyer at least. I noticed that they gave the junior lawyer the more difficult or basically the losing arguments to make, which seems like it must have been a deliberate choice by somebody. Now, maybe it was the junior lawyer that wanted those. Certainly would have been the way I would approach those things. You want the most difficult arguments because those are the ones where, you can show your stuff and answer questions from the Court of Appeal and make a little name for yourself. But maybe it was the senior lawyer that just didn't want to answer those tough questions. So just little things you notice. Okay, so I don't expect the Court of Appeal to agree with the Ecology Action Center, New Brunswick Anti-Shale Gas Alliance. I think they will confirm the decision of Justice Jameson, and that will be that for that claim. Okay, next one. I want to talk about this Antigonish Town and County decision or situation, which may affect other municipalities in Nova Scotia, perhaps across the country, but it's certainly heating up in this area with the town and county. Now, I talked about this in, I think, one of my earliest videos of this iteration where I do these weekly videos, but what's going on in the town and county is that both councils voted in favor of a consolidation process. All right, and the process they chose is that they would each would ask the provincial government to enact special legislation to consolidate the two municipalities. There's the county, the town is within that county. There's lots of development opportunities along the sort of border between the town and the county on the fringe area of the town. And lots of decisions kind of made artificially as a result of those borders and different jurisdictions. So there's some very sensible reasons why the municipalities would consolidate, but the problem seems to be for these residents the process under which, some people disagree with the substantive decision, of course, and the votes in council weren't unanimous. They were close votes in both the town and the county, but the residents disagree with the process. And now 27 residents of the county are suing the county. Now, the way these work with municipalities, you need to provide the municipality with a month's notice under the Municipal Government Act of your intention to file a claim. And so that notice has been provided and the residents have issued a press release to say that they've done so. But because the notice has been issued but the claim hasn't been filed, I haven't seen the claim itself. But given the comments of the group, I can imagine what's in it. I'm also curious to see who they have as a lawyer because they didn't note that, and no lawyer was quoted in the articles that I've read. So, in the Municipal Government Act, which I'm very familiar with because I've represented municipalities, including actually previously the County of Antigonish, up until a few years ago, so prior to all of these discussions. But there's 3 ways under the Municipal Government Act to have municipalities join one another. One is under Section 358 of the Municipal Government Act, which is an amalgamation annexation situation, right? So if you want to amalgamate two municipalities, regardless of what county they're in, I'll come back to that, then you can apply to the UARB, the Utility and Review Board, and then provide information, provide your justification for why that amalgamation should take place. And the test that the UARB would use is whether that amalgamation or annexation is in the best interests of the population served. So that kind of a process gives people a chance to be heard. Any resident or organization could appear before the UARB and make their pitch as well. But ultimately, the UARB decides whether that will take place. Okay, so that's one way. The second way is under Section 372 of the Act, and that is the Act section which allows you to establish a regional municipality. Now, a regional municipality should be the same as the first part, amalgamation, but this is a particular section for a county-wide amalgamation, which would, in Antigonish, there's only two municipalities anyway. There's the county and the town. In other places like Pictou County, there would be multiple municipal units, and so this might be more of a relevant section. So, but again, the steps are that the councils within that county would vote in favor of becoming a regional municipality. There would be studies done on the best form of government for the county, and then, crucially, the issue would go to a plebiscite, and everybody in the county would vote. Everybody of age and majority would vote, and if it's a majority in favor of amalgamation, of creating a regional municipality, then it would be granted. Well, that wasn't done here either. The third way is if the town actually dissolves, and we've seen this in other areas. The town of Canso, Quebec is looking at this, and if the town dissolves, then it basically becomes part of the surrounding municipalities. So in this case, the town of Antigonish, were it to dissolve, it would more or less automatically become part of the county. There's some involvement again with the UARB. You need to apply to the UARB, and all parties involved can be heard. Groups, individuals could come in and speak to the issue as well. And there are studies done. There's no clear test of what is done or why it would be done through the Municipal Government Act. The only sign of what might be the criteria was if a town seeks to dissolve, there's a provision in there that financial studies have to be done to see what the financial impact of that would be done. Basically, I know when Canso dissolved, there were studies done on the financial impacts to see whether the taxes for the rest of the residents of the county would go up, and that allows the municipalities to then go to the provincial government and say, okay, well, if we're going to absorb this town into our municipality, then we need some additional funding in order to make up for the shortfall that's associated with, their public works or whatever. So those studies are done. So in all three cases, there's some opportunity either to go to the UARB or to have a plebiscite if it's a regional municipality. And the regional municipality model seems to be the one that speaks most clearly to what the two councils are trying to do. But what they've done instead is they've applied to the province to say, or they've made motions that they're going to apply to the province to say, we'd like you to do special legislation to consolidate us. So to me, that makes this lawsuit premature. The councils haven't violated any of those three sections of the Municipal Government Act. The motions passed are only asking the province to do something. They haven't and they can't compel the province to do something. So now, if the province does create special legislation to circumvent the Municipal Government Act, then perhaps there's a claim there. But I just think this is premature. There's nothing tangible yet. There's no real decision yet. Nothing has happened in a practical sense, in a justiciable sense, to fight. So I think that's what the court will find if this gets to that point, that the claim is premature, unless and until, because the province might just disagree and say, no, we're not going to do that. Go to the Municipal Government Act. That's what it's there for. So if that happens, then there's really nothing to litigate here. So I think the citizens are premature in doing what they've done. Okay, final issue. I want to talk just briefly about Bill C-21. The way this came through the Parliament, this is the legislation that's been in the news about firearms. The original intent seemed to be to restrict handgun possession and usage in Canada. And at a certain point, the Liberal government tacked on these other guns and these other amendments. 478 pages of amendments, according to the news article. I haven't read them all, but the problem, well, there's several problems. The substantive problem is that these amendments capture lots of hunting rifles, like the SKS semi-automatic, which was designed in 1945 and is used by some hunters, antique and expensive firearms that were made pre-1900, and this .22 caliber hunting rifle that some people seem to call the plinkster, because you plink tin cans off a fence with it, target shooting. So normally legislation, there's 3 readings in Parliament, and then the same happens in the Senate. But just to keep it clear, we'll go with just the parliamentary procedure. The bill is introduced at first reading just to say, hey, here's the legislation, it's Bill C-21. Then on the second reading in Parliament, it's debated by all the parties just sort of on principle, what are the merits of this bill. And then after that debate, it goes to committee for sort of detailed study, a small committee outside the main body of Parliament. And after the committee, there may be amendments proposed that everybody on the committee agrees to, or at least the majority agrees to, and then it goes back for third and final reading where it's passed. Okay, so in this case, so normally if you're going to make amendments, it would be done during that second reading portion, and those amendments themselves would be debated. Here, it was after the committee debated and, thought about the merits of the legislation, and these amendments were added afterwards. So procedurally, it was a very sneaky procedural move by the government. And this is Paul Chiang, who's a member for Markham Unionville, who's a former York Regional Police officer. He was the individual, the MP, who brought these amendments in. And what they involve are any rifle that could accept a magazine of more than 5 rounds, though, so that's not one that already has, but could. Anything with more than 10,000 joules of energy, anything with a muzzle wider than 20 millimeters, and then a bunch of named rifles, including some hunting rifles. So we'll see what happens with this. I mean, the government could pass it, although I suspect they're going to have to make amendments to get a majority of Parliament to agree with them. But a very sneaky way to do things, something that's supposed to be, designed for one purpose, handguns, is then, added these long guns for, but mostly the way it was done after the substantive elements of it had already been debated. So really, sneaky, underhanded kind of a way to enact legislation. And anyway, so there's lots of opposition, including from Aboriginal groups across the country as well. This week at the AFN, I see they've made an announcement as well, not just the opposition parties. But certainly Markham Unionville, I don't think, is a particularly rural part of Ontario. But many, in the rural parts of Canada, hunting organizations and Aboriginal groups are very much opposed to this. So I can't imagine this passing as it was introduced, and certainly the government will suffer for the way they've brought it in. So just wanted to mention that as well, because not only for the substantive element of it, but mostly for the way legislation is typically brought in, and this was an aberration from that. So All right, lots of different stories on this week. Last week I just covered the one story of the Alberta-Saskatchewan legislation. This week there was lots in the news, so lots to cover, and so we'll follow up on any of these that require following up and look for more stories to bring you next week. So thanks to everybody for watching this. Thanks for listening, for those that are listening in on podcast, and we'll see you next time.